All right, welcome to the next episode of The Edge of Right. My name is Joe Graves. I'm a partner here at Graves Thomas, and my partner Matthew Thomas. And so we're going to continue our conversation, and we've talked about the edge of right. So Matthew, when you hear the edge of right, what comes to mind?
When I first heard the new tagline, "The Edge of Right," it was interesting because it was kind of put to me like I think most people are. It's going to be put to most people, which is just they're just reading it. And the first thing I thought of as when I applied it to us is just that it makes me feel like we're on the sharp side of justice, on the cutting edge of truth when it's contested, and really just pushing everything forward to its peak pinnacle, which is the edge, but remaining on the right side of justice and on the right side of truth.
Yeah, I think that's interesting. The Teddy Roosevelt definition of the edge of right is basically, we went through this process. Yeah, it's branding, it's marketing, but our branding and our marketing, our commercials have always really been a reflection of us, of like who we are, because we've always tried to be authentic. We don't want to, appear to be something that we're not or that we don't back up in the way that we practice. And so we talk about that, there's just that uncomfortable space, between I use the analogy of like what it takes to get a B and what it takes to get an A. The extra work that it takes to get that. Are you satisfied with mediocrity? Are you satisfied with good? And what does it take to push towards excellence and making sure that the clients that we represent are getting the absolute best legal services that we could possibly provide? And sometimes it's not easy. Sometimes it takes a lot of extra effort, extra expense, extra time, extra work. But in the end, it becomes deeply satisfying to me, representing someone, and to the client as well, because the client deserves our best, and so that's basically what we mean when we talk about the edge of rights. Today, we're going to kind of talk about a couple of things that we face in the practice of law, and one being maneuvering through recent tort reform that was passed back in 2023. We hear tort reform, and kind of all different types of reactions from people. You know, people, yeah, we need to have stricter laws. There's too many frivolous lawsuits. Um, a lot of people have a misperception that, if you get in an accident, you're injured, it's a lottery ticket. And I'm sure you've heard all that before.
I don't know that from people who haven't been through the process and aren't involved in the legal system. Yeah, occasionally the uninformed.
Yeah, and so, in this community, it's a conservative community, and I can't tell you how many times I've heard people, "Well, I'm not the type of person to sue," or "I never thought that I would be in this position." And so it's easy to have judgment on something when it doesn't affect you, right? And these laws that get passed, if it's not affecting you, you might think it's a good thing. Yeah, okay, they'll take an extreme case, or they'll take something that seems unjust based on how they report it or how that it's portrayed in the media, and it motivates people. It causes anger. And anger is like the biggest way that we're controlled by politicians, by our government. We get angry about something, and then we're like, well, yeah, they use that emotion, and that's how they get these laws, because they try to justify what they're doing. But in reality, when these laws get passed, they're only benefiting multi-billion-dollar corporations, and they're taking rights away from the citizens and from people, and denying or limiting your access to courts, which is a constitutional right. And so the famous case that I think, if you've been around at all, you've heard about the McDonald's case.
Hot coffee.
Yeah, there's actually a documentary,
Great documentary.
and so people are like, "Oh, she got," I don't even know what the total award was, but millions of dollars because she spilt hot coffee in her lap, and people get outraged, and so that becomes something that, becomes the banner for the need for tort reform. And let's talk about that case just a little bit. You realize, like, I don't think most people realize that when that suit was filed, that all they wanted from McDonald's was to be reimbursed for their medical bill.
It, anyone who's using that case as like a discussion point for why tort reform is needed clearly has no knowledge about the case. That's actually why it makes such an interesting topic, because it was a case that was horrific. I mean, McDonald's is, I mean, and I haven't, you're testing my knowledge. I didn't expect to give a summary on it, so I'll do my best and on the facts. But I know that the coffee was extremely excruciatingly hot.
Superheated.
Yeah, it was
Between
like
180 and 190, it's usually served at like about 130, 135.
Yeah, so I mean, they were definitely burning the coffee bean over there,
For
and
sales.
yeah, for salespeople, and
It smelled better.
it kept it, I think warmer for longer, and they were providing, cups, and these cups aren't designed to hold something so hot, so there was a plastic melt, and they knew previously that it was too hot, but we're doing it anyway. Handed it to her, she grabbed it, and it in the drive-through. Um, Top came off, coffee spilled all over her. But if you look at the photos, I mean, they are absolutely gruesome. That coffee, I mean, I don't even know how she lived.
It was
To be quite,
horrific.
it was
It was
horrific.
horrific.
So and in that case too, the judge actually granted it a remitted her. So the original verdict was knocked down and reduced pretty significantly by the trial judge. I think maybe in response to some of like the public pushed outrage about the case, because it sounded, silly when you just put it into a she sued over hot coffee, and well, it wasn't just the hot coffee. Um,
Yeah, it was superheated coffee. They'd had prior customers get hurt because of it, so they were on knowledge that it would. I mean, they were on notice that it was dangerous and that people were getting injured, and they were doing it to boost sales. And all she wanted was her medical bills were like 20 grand. That's where this whole thing originated. And McDonald's refused to give her any type of compensation, and they're the ones that forced it to trial. McDonald's, and then they end up with this huge verdict because the plaintiff was sympathetic and the injuries. If you haven't seen it, what is it on HBO or
it's an HBO documentary, yeah.
look at it? It's horrific. It'll change your mind. It'll change your opinion. But it's a good example um how things and how thought about particular topics get manipulated, because what was reported was like this lady gets millions of dollars because she spilled coffee in her lap.
Mhm.
None of the gruesome details or the specifics of the case were reported, and so it became kind of like the flagship for motivating tort reform. And so, basically, what happens is that you know and it's a tactic we see over and over again, right? People get outraged, they get anger, and then that anger becomes weaponized, and then that weaponization of anger then um leads to some type of tort reform, which we had earlier tort reform. But, you know, if there are frivolous lawsuits, which has always been, you know, my position, and I'm not saying that every lawsuit, like every profession, there's probably cases that you could take a look at and say, okay, what are we doing here? But if there are lawsuits that are frivolous, we have laws in place to go after those people, and the attorneys or litigants or whoever's involved, if it's truly frivolous, you know why isn't the emphasis going towards and going for them versus like we're going to pass a blanket law that's going to prejudice all the citizens rights.
Yeah. Well, that's insurance companies like form super PACs, and they put their money together to market I believe manipulative tactics to try to get those people that they can reach more on their side and less subjecting to the legislature, because once the legislation is passed, that's when we're sitting here explaining it to clients, and they're kind of like their heads are spinning because by the way, most of your super progressive states, for everyone out there, Florida's, for having as many citizens as we have, very backdoor and backwoods in terms of our insurance laws. We have a lot of common law that has been slowly slipped away, whether it's with transitory substance, putting intentional tortfeasors on verdict forms and negligence cases, and these are all passed because, one, people don't people don't even know. I think there's probably people listening right now that are thinking, I still don't even quite understand what he just said, and that's just because there's little nuances to tort law that, if you can whittle them away, we become, basically a state where you can no longer hold people accountable for their wrongdoing. It's sad, and it's a travesty, and it's something that happens because our legislation and legislators are looking for a buck, and people don't know what rights they're losing until they're gone, unfortunately.
Yeah, it's truly, that's what happens. People don't realize what they're voting for or what they're supporting or how it affects them. And then the people that are voting on these things, I mean, a lot of them are not lawyers that have never tried a case, never been in this situation,
No.
and the limiting of economic damages or what you can
Yeah.
put forth before a jury. And so it's just always been puzzling to me. I would consider myself a conservative person, but I
Mhm.
always feel like, it's a kind of a common sense proposition that if you cause a harm, if you are a wrongdoer or you're negligent, like, you should be responsible for that. And it's not like,
That's how it was when our country was founded.
yeah, the thing is, if someone's injured and they incur medical expense, it's not like those expenses go away because you have tort reform. They get passed on in other ways. So if the person, for instance, doesn't have health insurance, well, then they go to the hospital. Who's paying for that?
Me.
The taxpayer.
That's right.
Right.
You.
So instead of holding the person that did the wrong responsible,
Mhm.
you're spreading it out
Mm.
to other entities or perhaps even the taxpayer. So to me, like, it doesn't make any sense why you would want to do that. And the only entity or entities that benefit from this are the insurance companies.
Absolutely.
And they put this stuff out there because, look, they want you to read this stuff. They want you to see all this stuff. Oh, we have such a problem with tort. We need tort reform because they're poisoning the juries. People, I mean, when we pick juries, right, we always have this topic comes up and people have opinions, strong opinions, some for, some against, and some kind of in the middle. Well, they say they're in the middle, but
Mhm.
it's really hard to judge, and so that's a lot of the reason they're doing it too. And so when I see though how this anger, like for instance, over McDonald's case was, I'm just going to use maybe a dramatic term, but weaponized. But
Yeah.
then the Tampa Bay Times did this story, I think it was last year, that revealed that insurance companies were diverting billions of dollars of profits that they were generating in the state of Florida. They were moving them to their subsidiaries or other corporations outside of the state of Florida and then saying, with the hurricane claims, well, we don't have the money to pay the claims, or we've got to raise rates because they've taken all the profit and they've moved it out of state and benefited whoever,
Mhm.
corporate officers, shareholders, whatever.
Yep.
And then,
Yep.
they come
Sold
back.
us a bag of goods. They used that, Joe. They went in front of the legislature and said, and by the way, I like know the insurance people who get behind you. I can promise you, after they passed those statutes, they got together. They were cheersing the high end whiskey, laughing because they just took advantage of our state to whittle away our ability to make claims for the insurance that people were paying premiums on. They use that basically as their final straw. Look, we're not profiting here in Florida. Well, come to find out, not only were you profiting, you're profiting more than you've ever profited before, and it was off the back of Floridians. We were literally the state that was getting them all, like the highest degree of profits. There's no public outcry, and to be quite honest, I think that it should render our legislation invalid. I mean, you have all these bases that are argued as the reasoning, and it just turns out that the insurance companies were just playing, three card Monty, a little bit of hide the eight ball, and then once we discover it, it's they're trying to push it under the rug.
Yeah,
Really terrible stuff,
it,
actually.
it, it just
It's infuriating.
it just baffles me why there's not outrage about that. And so one of the things that they got passed, because of that, we're not making the premiums, we can't pay claims. They basically took away the right. It used to be if your insurance company denied coverage or denied your claim, you could sue them, and if you won, if you proved that they unjustifiably denied your claim, you could get your attorney's fees back. So attorneys would take those cases and know that they were going to win and get their fees back. Well, now they took that away.
Right.
Right. So, for instance, I have $100,000 worth of damage to my house on a hurricane claim. Now I'm some percentage of that. If you can't pay the lawyer an hourly fee and the lawyer takes it on a contingency, so now you got to pay a third of your benefits to pay the lawyer. And obviously, there's a lot less lawyers that are going to take those cases now because they're not going to be able to get fees. That's exactly what they wanted.
Yeah, that was the intention of it. Yeah, because I mean, you got just like you said, you got 10,000 worth of property damage. You have to pay that $10,000 to get your roof fixed. Um, but the insurance company just denied you when you go to get your reimbursement. You have to now pay a lawyer out of pocket to go and fight that. Sometimes the fees can, in that scenario in the past, the fees would far outweigh what the damage was. But the attorneys would take it knowing that they could potentially get the $10,000 paid plus their attorney's fees, whether it's $50,000, $100,000, whatever it may be, because it could be years and years of litigation, multiple trials, um, paid by the insurance company, who could have just paid the claim correctly in the first place. It's only once they've been determined to have wrongfully denied the claim that they have to pay. But now in that scenario, even if it's 2-3 years, they don't need to pay those fees, absent some sort of other method to get them.
Yeah, so that was the hammer. A lot of times, dealing with the insurance companies to get them to pay the claim. To be fair, I mean that's all we're trying to do here. Just be fair. You got to have that hammer, and the potential for attorney's fees or paying the other side's attorney's fees was a hammer that you could use to get your claim paid. Now that's been taken away. So, I think it's absolutely terrible.
It's just it's not, yeah, no, it's an abomination, and I can tell you that from someone who speaks with first party property damage lawyers, the business has completely changed. People are getting really screwed. For those of you who go to make a home insurance like a roof claim in the next 4 years, you're going to see it because you're going to get denied, even if it's legitimate. And then if you're a non lawyer, you're likely going to have to go and give up some of those funds. That's hard money. I mean, you actually need that money to rebuild the roof, but you're going to have to go pay a lawyer to go out and get it, because they're going to play silly with you on coverage until their backs against the wall and they feel like they have to pay, and then they'll pay. But
What's the hammer? I mean, what's the motivation for them?
yeah,
To pay the claim,
yeah,
because we're not going to get hit on fees.
yeah.
Okay, I lose. I pay what I would have paid anyway. Maybe I can win and maybe not have to pay you as much.
Hmm.
But if I lose, I pay you what I was going to pay you anyway. And now you lose, even though your claim's been wrongfully denied because you can't get your attorney's fees paid.
And people might say, well, what about the attorney's fees that the insurance company has to pay? But I would say that in these types of cases that we're talking about, where you can really kind of like highlight the absurdity and the outrageousness of it in the factual scenarios that we're giving you. They're almost all in-house attorneys, so that means that the person's just paid a salary. They're given thousands and thousands of claims to handle, but it's not like something they're paying out like an hourly rate of $400, $500 an hour, 600, whatever.
Yeah.
So they really don't feel the sting of the attorney's fees like you might think they would.
Yeah. So one of the other things that past, and we'll let you talk about this since you do our litigation here. Talk about how economic damages and what we can put before a jury, how that's been changed and how that's been limited.
Yeah, lots of debate over that. This one, um, before what we used to do is we used to go in front of a jury. You had an amount that was billed, and you would put forth that billed amount because that's technically the reasonable value of the services. There could sometimes be set offs, but that typically was done by a court afterwards. And the reason for that, we were trying to keep from juries collateral sources. Our legislature previously had thought that collateral sources, which is a source of payment, whether it's Medicaid, Medicare, workers' comp, whatever it is, shouldn't a jury shouldn't know about that because it can influence a jury's thoughts about whether someone's double dipping or trying to get money that they don't deserve, and it can kind of pollute their mind. So it was excluded from evidence. After the legislation passed, the new statute, which is in some I don't have it, but it's in chapter 768. Um, that statute now has some specific uh, provisions that control the admission of medical damages. So that's in the past and in the future. There are different interpretations of this statute right now. So that's something that we're seeing in the courts. We're kind of, is it a condition precedent that I have to show to the court what these reimbursement rates are, or as I read it, just a permissive way to submit evidence of the reasonable balance or reasonable bill uh, for reimbursement of medical services. And I know it sounds a little confusing, but I think that it was intentionally crafted in such a way to create that ambiguity because really the court didn't really the legislature was trying to get it so it wasn't unconstitutional. And if they can keep it if they can keep it from being unconstitutional, then they can keep it in effect. And so if they really committed to what I'm saying that's being argued, this condition precedent that it has to be done this way, and you can't use other evidence to show what the reasonable value of the services is, which is, historically, and by the way, in almost every other state, the way it's done. Okay. In Florida, and it's so funny talking to lawyers out of the state, like they start like scratching their heads, like what? And it's like, yeah. Um, so now now there is admissibility, whether, however you read the statute, I think it is admissible pretty clearly. Maybe the plaintiff doesn't have to put forth the evidence, but it is admissible. Medicare reimbursement rates, I think it's 120% of Medicare, 170% of Medicaid, of what their reimbursement rates are. And so now we've just basically seemingly, washed away the collateral source rule, but also allow for, um, really rates to come in before a jury that don't have anything to do with the price of tea in China. That's how I say it because, I got a client who's 35, they're not on Medicaid. So why are Medicare or Medicaid rates even being discussed? Who came and said that that's what the value of a private doctor's services should be? Um,
Well,
your
first of
your
all,
your
Medicaid
governor and
rates aren't
legislature.
aren't based on value of services. It's a poverty
Correct. Right.
situation, so
Exactly.
it's not based on value. Yeah, and so I mean, we talk about collateral sources. So it used to be, if a person was injured and they had insurance, and there was a benefit to having the insurance. So whatever benefit that might be, it went to the insured. I mean, they went to the person who actually went out and bought the insurance and took care of themselves and took care of their business. Now that's all gone away. And so when you're talking about um, what you can put into evidence, so we're talking about like let's talk about past medical bills first.
Mm.
What can you put into evidence in a trial with regard to past medical bills?
So this is why the statute's so interesting, honestly, because there's almost like you say past medical bills, everyone's like, oh, what a straightforward question. Well, let me break it down for you. Like there's past medicals that have been paid. There's past medicals that have been partially paid. There's past medicals that have been um, billed, but maybe they're not owed under a letter of protection, which is actually like there's a whole section of this statute. It's a really long statute. There's a whole section of this statute talking about letters of protection, and it's the worst part. Like, we haven't even got to that. We're you know
We talk about that in just a
yeah,
minute.
that's the worst part of that statute. It's total, just a con job, honestly. I don't even know how to say it any better or lighter. Um, but with the past medicals, if the bill has been paid by a private health insurer, for the past medicals, that's the amount that you can claim, and you can't exceed that. However, you can use for unpaid charges various types of evidence. And again, it just comes down to how you read the statute and what your position of the argument is. Is it a requirement that the plaintiff has specific coding and diagnostic coding or ICD codes for treatment? Or is that just a permissive way? Because I don't want to get too far into the weeds, but the language of the statute, including but not limited to, that's very specific language that was used by the legislature. They did it to keep it constitutional. That's why they throw that in there, to kind of confuse people, keep it constitutional, because if you remove that, it's clearly unconstitutional. um and so, that's how you submit medical bills. And I think judges are struggling with it, because you see different rulings across the state. Different judges see it different or read it different. So that that becomes a big fight in all the cases that are going towards trial or get to trial.
Yeah, so here's the issue. I mean, if you've been to the doctor, to the hospital, and you've received an explanation of benefits from your insurance company, I'm sure you look at the bill and you see what the bill is, and it's, X. The insurance company then and we just went through this with Florida Blue with Cleveland Clinic, but they negotiate a contract rate for services based on what they do. And then they pay this agreed amount, for doctors that are in their network. Okay. And that's what you're talking about. So when you put those past medical bills in, you know, you're restricted to putting in what's actually paid pursuant to that contract rate that's negotiated by whatever insurance company, if you have one, right?
Right.
Um,
You still got to pay the insurance company back, by the way. It's not like that.
yeah,
It's like you just get to pocket that money because the insurance company paid it.
that's
They
true.
got a
I was
lien.
surprised with that.
Yeah, so it's like you get yourself you got $10,000 worth of insurance benefits that paid for $100,000 worth of treatment. If you get that $10,000, you got to pay that to the insurance company. So it's not even yours, and it's obviously tampering with the value of the bills for the futures.
Yeah. So the way it used to work is that you could put in the total bills, and then the judge, after the verdict, would go back and say, okay, there's a set off based on what's been paid, right? But you could at least present to the jury like what the value of the services were that you received as a result of your injury. So, I mean, and the reason for that is because if you study jury verdicts, you'll see there's kind of a saying that says economics drive the verdict. So, um, it gives a jury a clear, and I would submit a fair look and glimpse into what a person has gone through, their injuries, and you know, how much they should be entitled to be compensated for when you look at like those total bills. And it's not like the people were walking away with like the extra cat. No, that was getting
Y-
reduced post
y-
verdict. So then when it becomes interesting is you're also entitled part of your economic damages in a civil lawsuit, say a motor vehicle accident, premises case, or whatever. You're entitled to future medical bills that you're likely to incur as a result of the accident. And so this is now gets a little tricky.
Well, yeah, but before you even get there, Joe, there are people that don't have health insurance, don't have Medicare, don't have Medicaid. They go to a doctor. The doctor gives them a bill. They say, "I performed a service. Here's 5,000. You owe me $5,000." Okay. There's no insurance, so the person they don't have a means to pay. They owe that $5,000. If one, the rates that you can submit for reimbursement can actually, or if, for instance, maybe you want to go to an out of network provider, right? You go to an out of network provider, same thing. They're not taking your insurance. But you're owed this bill. You can actually only claim as a claimant, as a plaintiff, you can only claim what the insurance company would have paid, and you have to have the bills actually put up. Okay. So now, if you think about it, they're not legislating what a doctor can charge. Okay. They're not legislating how a doctor can charge. They're only legislating what you can claim with a jury. So it actually creates this hypothetical, nightmarish situation where your provider is saying you owe $100,000 worth of medical bills. You're legally only entitled to put forth evidence of like them being under contractual rates of like 30,000,
But it's non-existent.
but it's non-existent, and you still the providers don't have to abide by that, right? The providers can go, well, I billed this. There's no law that says I can't bill it, that you don't owe it.
So say a doctor says, I don't want to be in the Florida Blue program.
Right.
I don't like their reimbursement rates. I don't want to be subject to their billing rates. I'm opting out of that. And we see that now with concierge doctors. And this is a big reason why you're seeing a lot of concierge medicine now, because they're of this game that insurance companies play with their reimbursement rates. It's really not based on anything. It surely isn't based on the value of services.
Yeah.
But now you're exactly right. I'm so glad you brought this up. So you have a person who doesn't have insurance and they owe this bill. They're not under a contractual rate with anyone or any company, but they owe X amount, $10,000 for the bill, but to the doctor, because he says that's what my services are worth. Because the legislature can't tell a doctor what he can charge for his services.
Right, of course not.
But then all of a sudden, they're limiting you on what you can actually, be awarded. So the person, even though, you may be sitting at a red light and get rear-ended by someone at 50 miles an hour, and you've incurred these bills, and now all of a sudden you can't even get compensated for them.
And the doctors bill a very specific way. I don't know if you guys have ever looked at doctor bills. They're very unique in how they each do them different. But they require plaintiffs now, if we're going to submit these bills, and it qualifies under certain sections of the statute. We have to actually like set forth the ICD code sometimes. So we have to actually put the coding, the billing.
Explain what that is.
Yeah, these are like the diagnostic codes that are used for insurance purposes. Basically, if you go to a doctor and you have a physical exam, there's an ICD code that's associated with diagnostic code associated with that for the computer and for Medicare, Medicaid, but a lot of times previously doctors weren't necessarily even using them because they were saying, well, look, this isn't even for insurance. I'm not even submitting this. This guy's at a network. I'm not going to do that. So, and again, they're not forced to do it. Okay. They're not actually even forced. That's the thing. It's not like the insurance company or the legislature came in and goes, look, we're gonna restrict and enforce laws about billing for these doctors about how they bill. They're saying, no, you go ahead and bill whatever you want. But plaintiff, if you want to claim that billing, here's how you have to do it. And so sometimes it creates just like an impracticality, because if the very provider who's performing the services isn't using the coding and coding it right, how on earth are you going to be able to put that together as a plaintiff?
And the coding isn't straightforward. Like, for an example, it could be like an exam with minimal judgment, or if there's some type of procedure or some additional thing they do during the exam, it's very specific, and the codes then dictate what the reimbursement rate is, but they're very specific about what has happened or occurred during that encounter with the doctor. There's like all these little different things that can change the code or what the reimbursement rate is. And now you're talking about trying to go back and recreate that because you have a doctor that's not even billing insurance or involved in all that. It just becomes a nightmare. And, the thing is like, we represent people that are victims. They've been victimized because somebody else has done something else wrong. And yet now we're putting the victims through all this just to try to get medical bills paid. it's insane.
It's really sad state of affairs, and I mean, there's a growing trend in the medical legal profession, just not even submitting the bills. I mean, I know this sounds crazy. I mean, they're almost like anchors now, where they kind of pollute the jury's mind about the value, because you're, instead of putting forth 100,000, you're only putting forth 5,000. So when they go to think about the futures or pain and suffering, they're thinking, well, they only owe $5,000. If for medical expenses, or not even that, they're thinking, well, the total medical bills are only 5,000. It's not even like that's what they owe after the total amount billed. You're just submitting what's been paid. So yeah, there's that's a strategy that people sometimes use, not even claiming the medical bills, which again, it just shows, because that's exactly what they wanted. They go, yeah, they're going to make it so difficult for plaintiffs lawyers, that plaintiffs lawyers are going to go, you know what, I'm just going to not put up the bills. And now all of a sudden, well, it's like, great. The insurance company's like, great, there goes another 40 grand I don't have to, worry
Well,
about.
it's the doctors too, though,
Yeah,
because
totally.
if you know any doctors, there's doctors like, I don't even want to mess with Medicare because of the way I have to submit bills and
Yep.
all that sort of stuff. This comes into play as well. And how many times have you heard people in our little community, they get in an accident and they go to their family doctor that they've had 20 years, and they're like, "Oh, you're involved in a motor vehicle accident. I can't see you."
Right.
That happens very often in our locality here, where they don't want to get involved. If Cleveland Clinic, you get referred to a doctor there, and you're like, I'm in a car accident, I need to see a spine surgeon or whatever. They're not going to see you. So it really, and this is the chilling effect, I would call it, of all this. And so then when we're talking about the future medical bills, we were talking about, it gets complicated too, because then what is the fair value of the reasonable medical expenses you're likely to incur from the car accident? I think you talked about, or premises or whatever. I think you talked a little bit about this. There's kind of a split of opinion right now in the courts on how they're dealing with this. But there is, in the statute, as I understand it, it's admissible what other reimbursement rates to show values of
Hmm.
services.
That's right.
So, you know, look at it this way. I mean, if you need to have a surgery, which is very scary, um, there's going to be a difference in certain surgeons, like who you'd want to go to, who you would trust your body to. And then how does the court then impose these restrictions or value services, like all doctors are equal? If I have a shoulder surgery, I could go, somebody, I don't know, where I could go to Dr. Andrews in Birmingham, who's a world famous, shoulder surgery, does athletes. Well, who gets, you're going to tell me that does reimburse the same?
Joe, I don't want to scare anybody out there, but I don't even know in 5 years if Medicaid or Medicare is even going to exist. Okay. Because you got people that are attacking it. So, who knows what the future holds, but you being limited to current, rates for Medicare, when you're talking about maybe someone who's got a lifespan of and future medical treatment outlined for 20, 30 plus years, it just, it seems very unfair on its face.
Yeah, the other thing that changed was the statute of limitations on negligence cases was shortened from 4 years to 2 years. Maybe that seems reasonable, but if somebody's in a severe accident, has significant injuries, like, it's hard to determine sometimes. I mean, most, cases, it's fine. I mean, we kind of had a 2 year statute of limitations rule in our office anyway. We try to get cases, resolved or filed by that time. But now you're really under a time crunch. And if people have significant injuries, you know, um, it can be a problem, the 2 year statute at times. Maybe you file the case before it's ready to be filed or whatever. But, again, another attack on people's rights. The other thing, you mentioned letters of protection. And so there, we all know, we watch the news. Like, there's a significant portion of our population that doesn't have health insurance, and they're even trying to attack the Affordable Care Act. We've had a lot of people that have benefited under the Affordable Care Act. So maybe even if your physician isn't accepting Affordable Care Act benefits, the hospital probably is, or if you need a surgery or if you need to go someplace. So it becomes very beneficial. It opens up care for people that might not otherwise have that ability. But think about this, like, you don't have health insurance. And there's a lot of people that don't because of the economy, and health insurance is terribly expensive. Um, you're in an accident, you need surgery. What do you do? Yeah. So there are some doctors out there that will work on you kind of like an IOU. They'll sign a contract with the plaintiff. Like, okay, I'm gonna go ahead. You need this care now, so I'm gonna go ahead and provide it. But then I'm gonna, take that, have a lien basically against your settlement proceeds. So you could pay me back later when this case resolves and you get compensated, like you should get compensated. But now again, weaponized, you know, um, that all gets turned around as though the doctor is biased, like the doctor has some interest in the outcome. The doctor is going on a limb providing services, hoping that you're going to get compensated. And we've talked about how insurance companies handle these claims, delay, deny, defend. I mean, we've got cases that seem clear as day, and it's a dogfight. We got one right now.
Mhm.
It's a issues seem so clear.
You got a lot of them, yeah.
It's just a dogfight. Every turn, is like a major issue. And so getting I think most people can relate with the hurricane claims happen. It's just such a fight in some of these cases for people. And then the victim, like the person who they didn't do anything wrong. Like they're sitting there, and they get hit, and now they might not be able to work. They got these injuries, they got these problems, they got disabilities, and like everything is coming against them. Ability to get compensated, ability to get your medical bills paid,
Yep.
submit your future medical bills.
Yep. And the statute, the worst part, I got worked up earlier about the letters of protection because now not only are they discoverable, and I think they've been discoverable for a few years, but we have to produce them to the other side. So we have to give the letters of protection that are entered, if it is a true letter of protection, without a showing. Otherwise, we can't claim those bills. And once there is a letter of protection that's been entered between a plaintiff and a doctor, signed by that used to be the old way. It used to be signed by an attorney too. Now I think the courts are kind of, think that you can jump that step. But if they find that there's a letter of protection, um, if you were referred to that doctor by your attorney, and a lot of times we like to think that there's an attorney-client privilege. For all things. People can talk to us candidly, ask, clients would ask, hey, well, what doctor should I go to? Who's gonna be able to give me the best care? Who's gonna be, you guys see this all the time. Who's gonna be able to do the best job for me so I can get healthy? Well, if we tell them the name of a doctor, so I say Dr. Seuss. Well, if they go to Dr. Seuss and get care under a letter of protection, the fact that I told them about Dr. Seuss is now discoverable. And if I've told other claimants and referred them, plaintiffs, to the Dr. Seuss, that's also discoverable. So in a small town, in a small area where there's only really so many doctors that someone can even go to, um, they basically made it to try to manipulate a jury's perspective about what's going on with the case, and secondary gain motives, and basically make it look like it's a setup scam when it's far from it. Really, we were just advising our clients in confidence. But that should scare people because like the legislature coming in and saying, hey, there's a non-criminal, um, you know, perfectly ethical and responsible communication that's being exchanged between a client and their attorney, we are entitled to now hear that and use it against you, by statute. And that is like to me probably the scariest, slipperiest slope of all time, because the cornerstone of the attorney client relationship is that privilege. If people think they can't talk to us straightforward, or we think we can't talk to our clients straightforward without it being protected, um, I just don't know where that goes, or how our legislature was able to think that that was an acceptable outcome, for people. Um,
Yeah, and the defense always in these cases, they attack it as like it's always some kind of conspiracy or some type of claim that's contrived or whatever. And I'm sure there's lawyers out there, you know, I would say maybe hopefully a small minority that will send to doctors, and maybe the doctors are giving them, I don't know. But we don't operate that way. We're in a small town, and like I said, many times clients will come and say, I went to my primary care doctor and they won't see me. And then there's other surgeons like at Cleveland Clinic that won't see them when they say they've been in a motor vehicle accident. And so now the choices become very, very narrow.
yeah.
And then if you talk about like doctors, there's not a lot of doctors that'll do it on an LOP or an IOU, like especially like a surgery. Like I'll do this now for you and hope that I get paid later. I mean, nobody does that.
Yeah, especially the major surgeries, like reconstructions or something where they're actually trying to, you need someone to help fix this person. Maybe a surgery went wrong, or because you think about it, there's anesthesia, there's surgery
Yeah,
center, there's equipment, all of that.
and I think they ask, when we do get asked, we encourage clients to treat with their doctors that they have or they have a relationship with. But if we know, I mean, we see who has successful surgeries, who doesn't, and personally, I would never refer a client to someone that I wouldn't refer my own family to, because I want to make sure that our clients get the best care, or into somebody that I would personally go to, or I would take my wife to, or my kids or something. It's not nefarious. um and yet that it just becomes weaponized. It tries to create this perception of something that isn't, all in an attempt to persuade a jury or create doubt in a jury's mind. And the thing is like, if someone hurts somebody, where's if I hurt somebody, I would feel responsible for that. Right. And I think most people think that, look, I've had this insurance company for years, if they're making a claim, or, they're insuring this person who did this, like they feel like the insurance company is going to help them or is on their side. And they're not. It's just all these little things, they start adding up. And then as lawyers, when we find our way to work around these things and to address them, they just keep adding on and adding on, pitfall after pitfall after pitfall. And this is all happening, and hopefully the majority of people listening here have never been in an accident and don't ever get in one. But all of a sudden now you find yourself in the middle of this system, and all these things have been passed, all these rights have been eroded, this pathway to just get just compensation, has been taken away. And we're just sitting by, watching it happen. And it's scary to me. And who benefits? Who is the benefactor of these laws getting passed, of your restriction to being justly compensated? Multi-billion-dollar corporations.
Yeah, and remember, there's only two ways an insurance company ends up paying money. Okay, so if you think about from the insurance company about, oh, they're overpaying or something, that, well, okay, well, they're either voluntarily agreeing to pay an amount. So we know that amount is fair because that's the amount that the insurance company is actually agreeing to pay. The only other way that they're going to end up paying is because of a verdict and a judgment entered against them. So we know that's fair because the jury or the decision maker, the judge overseeing the case, decided that was the value of the case. So that's also reasonable. So the whole kind of concept that the insurance companies are paying unreasonable amounts is literally a slap in the face, because it's you're saying, well, either you're voluntarily paying absurd amounts and now saying that, now claiming it. I don't know why you voluntarily agreed to pay that, or they're saying that juries are absurd. That when presented with the facts in a court of law, the juries are making bad decisions, because they're paying too much. Because other than those two things, there is no payment.
Yeah. So, again, as we opened up, when we talk about the edge of right, we're talking about working through, maneuvering through these things. And, sometimes it does get a little uncomfortable. Like sometimes we find ourselves in a position where, to do the right thing, you know, we have to stand up and we have to stand up for our client. We have to do the right thing to make sure that, we're getting our clients what they deserve. This isn't a lottery system. This is about getting people compensated what they deserve to be compensated when they have done nothing wrong and they have done nothing to deserve the situation they're in, and trying to achieve justice for them.
Yes, sir.
So, you know, you've been with me a long time. That's basically been the ethos of our law firm. We treat our clients like we would treat family. And this is what we would do if it was your mom or your dad or your cousin or your sister. Like you would fight to make sure that everything that's possible that can be done to make things right, to achieve justice, that those things are done. And that's what we do here. We're not going to sit back. And I know it's your word. I keep using it over and over, but precision, and so, we're dedicated to, increasing our technology and finding systems that make us more efficient so we can deliver a better service. We can deliver, you know, the best possible legal representation that is available to people. And that's what we've dedicated ourselves to. And that's what we're going to continue to do. I mean, the bottom line, if someone else causes harm, they should be responsible. It's common sense. And if the wrongdoer isn't responsible in making these payments and compensating the injured person, it's not like those costs go away. It just gets shifted, and it gets shifted to somewhere else and potentially to the taxpayer. I mean, as a taxpayer, I don't want to have to pay medical bills for somebody, that got injured because somebody was driving, too fast or wasn't paying attention or distracted or and caused injury to somebody else. And then, finally, just be careful when you read in the media about these type of issues, whatever it is, with these issues, political issues, because extreme narratives should not dictate policy. You got anything to add?
I agree. I think if you go back historically, our country is founded on holding people accountable. I think historically people were filing a lot of lawsuits personally back in the day when our country first started. I mean, historically, that's true. The average person was filing multiple lawsuits because, what's the other avenue? I mean, I guess you have a duel to hold somebody accountable. And if you can't do that, I guess you just got to chalk it up. So don't be I was just say to people, don't be bullied into giving up your rights, or because there is a systematic attack against everyone in this country, but specifically in Florida because they have a stranglehold on our legislation. But there's a systematic attack to our rights and to due process and to the things that this country was founded on. And so we're going to stand up to it, to the absolute best we can, and fight it tooth and nail. And we'll remain on the edge of right in doing that. And I hope everybody joins in our cause and supports us in that crusade.
Very well said. All right. Thank you, Matt.
Thanks,
This is
Joe.
Joe Graves signing off from the Edge of Right.
Ciao.